Any doubts in resolution applicant? Yes, those grounds are very important, people. I hope you guys remember them. Yes, people, all of you. You want me to quickly revise once more? Yes, sir. What and all you saw, people? The first one, people, he should not be a undischarged insolvent, a willful defaulter. People who his account only NPA, promoter, control, management. If at all they repay people, it's okay. Financial entity, not applicable. Should not be a related party. But if you are a related party because of conversion, not applicable. People, if at all you have acquired any of these people and then you have become a promoter, control, or management, then even for you it is not applicable. Not be convicted. People under 12th schedule up to 2 years or more. Any other law, 7 years or more. You should not be disqualified, people. Under your section 164, disqualification of director. You should not be prohibited for accessing capital market or any trading of securities. You should have not been a promoter, people. Basically fraudulent, preferential transaction, all that. Sir, everything, people. Guarantor, yes sir, and next string, people, everything from A to I happening outside India, and J, people, of all the connected people. That is what we saw. I hope it you remember. Okay, now, people, let us do resolution plan. Sir, what do you mean by resolution plan? So, people, I hope you are going with the flow. What is happening, sir? Information memorandum was prepared. We are asking for the resolution applicants. Who and all you think you guys can revive the company. So people, whoever think they are eligible enough, they will submit their resolution plans. Sir, the resolution plans, first thing what will happen, people, whoever is our resolution professional, RP. Now this person will sit and he will try to assess. Okay, whether this given plan, is it, they have given everything or not? Have they considered everything or not? So everything will be kept in mind, people. If at all the checklists are satisfying, the resolution professional, if he feels everything is fine, the resolution professional will take that resolution plan, he will go and he will present it in committee of creditors. How many ever resolution plans we get, people? Only those things which are shortlisted. You think that everything satisfies the condition, it will be submitted in the committee of creditors. Now they will vote, people, accordingly. We'll see that. Sir, a resolution plan means a plan proposed by a resolution applicant. Yes, for resolution or restoration of a corporate debtor. As I told you, people, it's a plan to bring the corporate debtor out of this CIRP process. It has to be approved by a vote of not less than 66% of financial creditors. Yes, people. So first, what will happen? A resolution applicant. People, resolution applicant. In our case, let us take Adani. Resolution applicant may submit a resolution plan along with an affidavit. People, affidavit means, people, it's a swear that whatever I have given, I am giving whatever is truth. I'm not going, whatever is the things I am stating, I'm not going against it. Whatever is I am stating is true. What are you stating? Stating that he is eligible under section 29A. Sir, ye kya hai? 29A. People, go back the previous class, whatever we did, that is only 29A. So people, you need to give a declaration that I am not disqualified and I'm eligible to give this resolution plan. Who gives this? Resolution applicant gives this. To whom? Resolution professional. Don't get confused. Who is a resolution professional? Resolution professional is our IRP. IRP became RP, no? Sir, resolution applicant, he submits a resolution plan to the resolution professional. Clear? Don't get confused. So to the resolution professional prepared on the basis of the information memorandum. Information memorandum, biodata, all your financial summary and all maintained by whom? Hey, it is maintained by? Yes sir. It is maintained by people. It is done by resolution professional. It is given to the people who and all wants to bring or wants to come up with a resolution plan. Correct? All of you? Exactly. Sir, we'll come back to the second point after looking at the third point. Duty of the resolution professional on submission of resolution plan. Sir, now yes, I took a resolution plan from the resolution applicant. I took it. Now what is that the resolution professional needs to check? First thing, people, he needs to check that whatever is the resolution plan submitted, is it according to the manner for the payment of first one. Okay, resolution professional shall examine each resolution plan received by him to confirm that each resolution plan provides the manner for the payment of insolvency resolution costs in priority to the payment of other debts of the corporate debtor. People, what do you mean by that? Sir, whatever is a resolution plan you are submitting, in that resolution plan, people, the first priority should be for the insolvency cost. That is your CIRP cost. So first criteria, sir, whatever is a resolution plan you are submitting, the first cost in that towards which we want to utilize this, it has to be towards your corporate insolvency resolution costs, whatever we have done now. Okay. And next one, what else he will check? He will check for whether the plan you have given, does it provide for payment of the debt of operational creditors. Sir, whatever is the plan you have submitted, does it provide for the payment of the debt of operational creditors? People, why? The committee of creditors consists only of financial creditors. Sir, then what about the operational creditors? So people, what will the resolution professional do? When I get the resolution plan itself, I'll check whether you are satisfying all the conditions or not. If you are not satisfying, I'll reject it here only. Are you getting the point? Your concern was, if at all it comes to financial creditors, if they do not support, what will happen? Or a resolution professional will check the resolution plan when he gets it only. And people, see, for, you know what, whatever you guys think that, hey, if you are bad, lawmaker is your dad, says the lawmaker. People, the lawmaker, they amended this, people. Now, what is this amendment? I'll tell you. It may so happen, no, people, the financial creditors, they would want to, pull down this operational creditors somehow. So they may not give them the sufficient of amount what they should get. They may play some partial game. Possible, right? So people, what does the law say? The payment of other debts. Okay, where is it? It provides for the payment of debt of the operational creditor as may be specified by the board, which shall not be less than. Sir, operational creditor should be paid, and how much we are paying him, paying the operational creditors, people, that amount should not be less than. That means what? They should get minimum this or this. We'll see how much is that. The amount to be paid, sir, should not be less than how much? The amount to be paid to the operational creditors in the event of liquidation of the corporate debtor under section 53. Under section 53. Sir, ye kya hai, sir? People, listen carefully. What does the law say? You are doing all this why? Because we want to pull out the corporate debtor from the insolvency resolution process. Correct? Yes, sir. Sir, now you tell me one thing. Why did you go to adjudicating authority? Sir, so that we get a fair value of the amount. If at all corporate insolvency resolution process fails, what will happen? We have only seen that. People, it will go to liquidation. Yes or no? Yes, sir, it goes to liquidation. People now logically think. They should get who? Operational creditors should get minimum such amount, whatever they would get. If at all this resolution plan fails and the company goes into liquidation, when the company goes into liquidation, whatever is the amount they would get in liquidation, they have to get that amount here. People, what did I just say? If at all you go into liquidation, if at all the company goes into liquidation, resolution plan did not go through. People, how much ever I would get there under liquidation, people, that amount minimum I have to get here. Read, the amount to be paid to the operational creditors when in the event of liquidation of the corporate debtor, where under section 53, of IBC. Sir, 53 is not yet done. We'll be doing it much later. Sir, what is section 53? People, section 53 is this people. See? Sir, idiyen sir ido? Sir, yem sir ide? Sir, ye kya hai? People, idenna? People, it is section 53. Popularly in the industry is called as waterfall arrangement. Meaning people, waterfall arrangement. It is called only waterfall arrangement. Section 53 is important. Who will get first payment? Second, third, fourth. So people, this is called as order of repayment. Who will get first? Who will get second? Who will get third? People, it is prescribed in section 53. Whatever you have seen under Companies Act winding up is not applicable here. Is that clear? All of you? Awesome. Now see what does the law say. The amount to be paid to the operational creditors in the event of liquidation of the corporate debtor under section 53. People, why are we referring to 53? People, now imagine if at all operational creditors, imagine employees and all, if they come in the second priority, we'll just see when we go there. So people, now when the corporate debtor has 200 crores, that is what is net assets left. So sir, I will start distributing in this order. So in this order, how much soever I will get, people, that much amount though at least I should get. Yes sir, getting the point? Okay. Or the amount that would have been paid to such creditors, if the amount, such creditors, people, operational creditors, if the amount to be distributed under the resolution plan had been distributed. So sir, in short people, sir, whatever is the money I would get in liquidation, I should get at least that money, or people, whatever is the resolution plan, even resolution plan, people, we will be paying in this hierarchy only. If you want, you can pay in the same order also. Sir, whatever is the money I would get under resolution plan, if the payment is made as per resolution plan, sir, the law says whichever is higher. The operational creditor should get minimum of the amount which he would have got as per section 53, or if at all he is getting the money as per the resolution plan in the order specified in section 53, as the case may be. Sir, whatever is the amount, people, whichever is higher, the law says he should get at least that much. Yes, people, whichever is higher. Clear? All of you? Yes, sir. Okay. In addition to that, they prescribe one more thing. Sir, what is that? People, whichever financial creditor, now people, if at all our resolution plan should be accepted, people, we need 66% majority. So people voting with share 66%, they have to vote on particular resolution. Okay. Now what happens? Sir, imagine, sir, we got 70% approval. 30% they did not agree. Now what to do? People, the law says this 30% you will have to pay them. Whatever this 30, whatever is the people left out who said no, whatever is the money they could have got under liquidation, the same amount you need to pay. Generally, we call them as dissenting, if it is in the shares, you call them as dissenting shareholders. So same thing, people, the dissenting members, we have to give them an exit opportunity. Read. And provides for the payment of debt of the financial creditors who do not vote in favor of the resolution plan. Yes, sir. Which shall not be less than the amount to be paid to such creditors in accordance with section 53. So, sir, what did this section say, people? In this section, you saw three things. One thing, sir, first of all, you need to give a affidavit, resolution applicant, that I am free. And he gives a resolution plan to the resolution professional. Resolution professional needs to check that first thing, people, you are giving to the cost of CIRP. Second thing, people, whatever is the money, you need to make sure operational creditor gets at least the amount he would get in liquidation or as per the resolution plan, whichever is higher. The dissenting member should be given an exit opportunity. That minimum amount also people should be at least the amount they would get under liquidation. Clear or not clear? Yes? Okay. Now people, see the next one. For removal of doubt, it is hereby clarified that a distribution in accordance with the provisions of this clause shall be fair and equitable to such creditors. So people, tomorrow you cannot come and say, sir, how fair is it? People, they have only put an explanation. What is that? If at all a resolution plan satisfies all these conditions, then it is deemed that people, such resolution plan is fair and equitable. Clear? Yes? Okay. Explanation 2. For the purpose of this clause, it is hereby declared that on and from the date of commencement of IBC Amendment Act 2019, the provision of this clause shall apply to the CIRP of a corporate debtor. Sir, now what is this, sir? People, the IBC came into picture in 2016. Now, as and when the law is being amended, sir, before then all this was not there. This was introduced in the IBC Amendment Act 2019. The law says, people, sir, what about the resolution plans? I told you this was a recent amendment. Sir, what about those resolution plans? As on the date which this amendment came into picture, that this ordinance, sir, already resolution plans may have been submitted. What about them? What if they do not satisfy with this criteria? So on the date of amendment, what if some resolution plans are already submitted? What about them? The law said, that is what is this particular clause. The law says, people, the provision of this clause shall also apply to the CIRP of a corporate debtor where a resolution plan has not been approved or rejected by adjudicating authority. People, resolution plan is approved by committee of creditors, but it is not yet approved by adjudicating authority. It will come back because that resolution plan has to satisfy whether it is not yet approved or rejected. So it is still with the adjudicating authority, or before that you have to comply with this resolution plan criteria, operational creditor, financial creditor, all that part. Where an appeal has been preferred under section 61 or section 62, or such an appeal is not time barred under any provision of the law for the time being in force. Basically, people, you do not have sections after 60. Few here and there are sections are there. Section 61 talks about, people, even after the adjudicating authority approving the resolution plan, people who are not satisfied can file an appeal against such particular resolution plan. Sir, give us an example. They Twin Stars, we saw no. NCLT also has given approval for resolution plan, but they filed an appeal. NCLT has approved that appeal. So where an appeal has been preferred under section, so people, adjudicating authority also approved. Sir, but appeal has been preferred, people. The resolution plan, even in that stage, the law says it has to satisfy this criteria. Or where any legal proceeding has been initiated in any court against the decision of adjudicating authority in respect of a resolution plan. Sir, if adjudicating authority has accepted, but a legal proceeding has started in any other court also, the resolution plan is still coming under this purview. Is this clear, people? All of you? So, sir, under third, people, we saw first one. It has to first provide for insolvency resolution cost. Second one, people, operational creditor and resolution plans criteria and financial creditor. Sir, now the third one, sir, it provides for the management of the affairs of the corporate debtor after approval of the resolution plan. So you need to clearly specify once this particular plan is approved. The resolution plan should clearly specify who will take over the management, the implementation and supervision of the resolution plan. So it should talk about the implementation, which phases, how will it be implemented, and supervision of the resolution plan. The resolution plan does not contravene any provisions of the law for the time being in force. You are complying with IBC. What if you are not complying with any other law? You have to comply with all the laws. It conforms to such other requirements as may be specified by IBBI. Is this clear, people? Simple one. All of you. Perfect. Seeking approval of committee of creditors. This is what I told you. The resolution professional shall present such resolution plans. Such resolution plans, not one people. Imagine I got 12 plans. All 12 are satisfying criteria. I'll take all the 12 plans and I'll pass a resolution in the meeting. Yes, people. For its approval by a vote of not less than 66% of the voting share of the financial creditors, after considering its feasibility and viability in the manner of distribution proposed, which may take into account the order of priority amongst creditors as laid down in section 53. People which may take into account. So when you're repaying the money, you can go as per whatever is given under section 53 subsection 1, waterfall arrangement. But that comes when liquidation is proposed. You may follow that order also, is law saying. Yes, people. Including the priority and the value of the security interest of a secured creditor and such other requirements as may be specified by the board. Note, Committee of Creditors shall not approve a resolution plan submitted before the commencement of IBC Amendment Ordinance 2017, which came into picture on 23rd 11 2017 November, where the resolution applicant is ineligible under section 29A and may require to invite a fresh resolution plan. So, sir, people, what happened, in this IBC Amendment Ordinance Act, which came in 2017, people, in that amendment is when they introduced section 29A. Until then, I told you, sir, even the promoter, controller, director, shareholders only used to give resolution plans. So people, what about the plans which are existing on 23rd November 2017 when this amendment came into picture? The law said, people, the Committee of Creditors shall not approve a resolution plan submitted before the commencement of 23/11/2017 where the resolution applicant is ineligible. So people, the Committee of Creditors should call for a fresh resolution plan. This person will not be given a choice. However, there is one choice, people. What is that? That is your next provision. Provided further that where the resolution applicant, whoever is ineligible, that is, people, a resolution applicant who is ineligible under clause C of 29A. What was clause C of 29A? NPA provisions. A person whose assets are non-performing asset. The law said, people, if at all yours is a non-performing assets case, then people, I will give you 30 days time. Whatever is your overdue, whatever you need to pay, interest, principal, everything, you pay and then you can continue as a valid resolution applicant. That is what they have given. Is it clear? Okay. Provided also that nothing in the second proviso shall be construed as extension of period for the purpose of the proviso of section 2, clause 3, subsection 3, and the CIRP shall be completed within the period specified. Sir, what is this? People, here we are telling, as on the day of the amendment ordinance came into picture. Sir, you are telling that I will be giving 30 days time to the resolution applicant whose assets are non-performing assets to repay the money. Correct? Correct. So, sir, the time given for me to finish the insolvency process is 180 days. Correct? Correct. Sir, so you mean to say I will get 180 days plus 30 days? Huh? The law said no, this 30 days will be included in this 180 days. So the 30 days, do not understand, do not read it as an extra 30 days you would get. It is not possible. Is this clear? Provided also that eligibility criteria in section 29A shall apply to the resolution applicant who has not submitted resolution plan as on the date of commencement of the insolvency bankruptcy code. So people, if at all, as on the date this particular thing came into picture, yes, who has not yet submitted the resolution plan, for him everything will comply. He needs to comply with the resolution plan, resolution applicant, everything he needs to comply. This is clear, all of you? Okay. Attending of meeting by resolution applicant. Sir, Adani, he gave a resolution plan. Sir, the law says, people, he may also attend that committee of creditors meeting. Why, people? Hey, you are only giving the plan. Now, what if they have any doubt? They may ask you. So the law says you may attend. people, but he can just attend, but he will not have any voting right. So Adani people who is a resolution applicant can attend the meeting of committee of creditors, but he will not have any voting right. Sir, what if our resolution applicant is also a financial creditor? The law says if you are a financial creditor, to that percentage you can vote. I will not have any problem. Is this clear, all of you? Okay. Voting on resolution plan. The committee of creditors shall evaluate the resolution plan, record its deliberation on the feasibility and viability, whether it will work or not work, vote on all such resolution plans simultaneously. So people, we got 12 plans, all that 12 plans people, we will vote them on them simultaneously. Now people, where only one resolution plan is put to vote, it shall be considered as approved if it receives requisite votes. How much is requisite votes? Sir, 66%. Imagine people, only one resolution plan was there and that resolution plan got 66% votes, then it is approved. That's all. Sir, what if where there are two or more resolution plans and both are put to vote simultaneously? Sir, now what to do? Very simple. The resolution plan which receives the highest votes but not less than the requisite votes, meaning, sir, I'll show you this, shall be considered as approved provided that where two or more resolution plans receive equal votes but not less than requisite votes, the committee shall approve any one of them as per the tiebreaker formula announced before the voting. Provided further that where none of the resolution plans receives requisite votes, the committee shall again vote on the resolution plan that has been received highest votes. Sir, now ye kya hai, sir? People try to understand people. Imagine people, we got two resolution plans, plan A, plan B. Yes, people, now the law says, sir, now it will be put to vote, both are put to vote. Only one is put to vote, sir. If we get 66% or more people, then it is approved. Sir, we are putting two plans. One got 55, one got 60. People, both the resolution plans did not get requisite majority. 66 we should get. We got 55, 60. So people, no plan is approved. In that case, what we'll do? As neither of the plans received requisite votes, the committee shall vote on plan B again, which received the highest votes. That is what you wrote in the last. See? Where none of the resolution plan receives requisite votes, the committee shall again vote on the resolution plan that received the highest votes. So 60. So we will give another choice for everyone to vote. Yes, people? Look at the second case. Sir, one received 60, one received 75. Obviously, plan B is approved as it received the higher votes and is also not less than requisite votes. We want 66. We got 75. What else you want? Sir, both got 75. Now what to do? The committee shall approve either plan A or B as per the tiebreaker formula. So people, based on the type of the meeting people, we will have something called as tiebreaker formulas. Imagine people like giving a casting vote. Imagine people, it is like telling that whoever is by number, whoever is more. Imagine 75% was given by two people, but this was voted by two people holding 75% interest. This was given by, say, 8 people holding 75% interest. So we may say that whoever is the maximum number may go through. So it can be differ people. It is your wish. But what is going to be the tiebreaker formula? It will be announced before voting only. People, whenever there is a equality of vote, this is how we are going to break the tie. We would have announced it earlier only. So accordingly, we will announce it. This is clear, people, all of you. Okay. So, sir, now resolution professional has prepared information memorandum, that is a summary. Based on that, a resolution applicant applies for a resolution plan, keeping everything in mind. Now it has been approved by committee of creditors. Now what will happen? Submission of the resolution plan approved by committee of creditors to adjudicating authority. Yes, people, if you go back to our chart, such resolution plan shall be submitted with committee of creditors for approval. So people, our committee of creditors, they may accept or they may reject. Now imagine people, they have accepted. It will be sent to NCLT for its approval. Correct? I told you, remember that one chart we cover everything. Yes. Adjudicating authority may approve the resolution plan. Adjudicating authority may approve the resolution plan, or adjudicating authority may also reject the resolution plan, as the case may be, as it deems fit. Now, what does the law say? If at all adjudicating authority approves the resolution plan, now what will happen? People, the approved resolution plan shall be binding on all these people. Who? First one, corporate debtor, its employees, people, members is your shareholders, creditors, guarantors, people who have given guarantee to the company, other stakeholders involved in the resolution plan. If at all there is any other person like governments or any other people, central government, state government and local authority, it shall be binding on everyone people. Corporate debtor, employees, members, creditors, guarantors, other stakeholders, central government, state government, local authority. It binds on everyone. Okay. Sir, once I give the approval, NCLT gave approval for the resolution plan. Now what will happen? People, whatever moratorium period you guys had started, the moratorium order passed shall cease to have the effect. Yes, sir. The moratorium period ends on date of approval of resolution plan by adjudicating authority. Day you remember this chart and Goda, you'll remember everything. The resolution professional shall forward all records relating to the conduct of the CIRP and the resolution plan to the board. Board people, IBBI. Sir, now whatever is the approved records, documents, committee of creditors approval, adjudicating authorities approval, everything people will now be sent to IBBI, Resolution, Insolvency, Bankruptcy Board of India. Yes, people, now IBBI will record on its database, basically on website, whatever on the first day we saw. Getting the point, all of you? The resolution applicant shall obtain. Sir, what if it's rejected? Where AA is satisfied that the resolution plan does not conform to the above requirements. What above? Whatever we have given here. It does not pay to the operational creditors properly. Financial creditors are not paid properly. Yes, people. It may by an order reject the resolution plan. Yes, people. So you may accept, you may reject. Okay. Now what will happen? The resolution applicant shall obtain the necessary approval. Okay. Now we have either accepted or rejected. Now let us go more deeper with acceptance. The resolution applicant shall obtain the necessary approval pursuant to the resolution plan approved within a period of 1 year from the date of approval of the resolution plan by adjudicating authority. Sir, now what is this, people? Sir, the resolution applicant, he has given a resolution plan. So now it is approved by committee of creditors and adjudicating authority. People, from the day adjudicating authority approves, from the day adjudicating authority approves, people, the law says whoever you are, a resolution applicant, the person who has given the resolution plan, people, he needs to take any other approval required from any other authority in India. Imagine, people, if at all there is a merger of a bank happening, a bank is taking over another company, people, then we may have to take RBI's approval. How long do I have, sir? I have 1 year time from the day I got adjudicating authority's approval. Yes, people. So see, the resolution applicant shall obtain the necessary approval pursuant to the resolution plan approved within a period of 1 year from the date of approval of the resolution plan by the adjudicating authority, or within such period as provided for in such law, whichever is later. So people, imagine, according to the banking laws, it says whenever there is merger, then you can take 2 years time for RBI to approve. So it will be 1 year or 2 years, whichever is later. So 2 years time you will have. Yes, provided that if the resolution plan contains provision of combination. Yes, people, now what is this? The second authority. Sir, if at all, imagine Adani Power is taking over Videocon. In India, people, whenever there are two people who come into picture, so that is, it is an amalgamation or people, a merger happens, people, then there is one act in India called as Competition Act in India. Sir, under Competition Act, people, we have established one authority called as CCI, Competition Commission of India. What is his role? People, he will just be looking in the India. Whenever you guys try to defeat the competition, this person will come and say, Ruko. Imagine people, Jio and Airtel enters into a merger. Now imagine Jio Airtel enters into a merger. Now if Jio gives one tariff, Airtel gives one more tariff. At least at 20 rupees, 80 rupees difference is there, competition will be going on. Tomorrow if there is only one service provider, whatever he says, you will have to listen. Do you have any other choice? So the law says the CCI will take care of such things. Whenever there is a combination happening, combination means people, it can be merger or amalgamation, which is defined in section 5 of Competition Act. So people, the law says if at all this particular resolution plan is resulting into combination, two companies coming together, then you need to take CCI approval also. என்னப்பா தலைவரே அண்ணாவண்ட் பாய் சாப் ஏவரே going inside people, all of you. Appeal against approval of resolution plan. Sir, I told you section 61 subsection 3 of the code, an appeal against order of adjudicating authority for approving the resolution plan may be filed on the following grounds. People, Twin Star had come up with a resolution plan. Committee of creditors also agreed. It goes to adjudicating authority. Adjudicating also agreed. Now people, whatever is a resolution plan which was approved by everyone, on this can you file an appeal? That is what we saw. No, they have filed an appeal. Now it is with NCLAT. On what grounds? The approved resolution plan is in contravention of the provisions of any other law for the time being in force. Sir, they have kept only IBC in mind, sir, but other laws are being violated. You can follow. This is a valid ground, people. You can. It is a valid ground, people. On this, you can go for an appeal. Yes, people. Next one. There has been material irregularity in exercise of the powers by the resolution professional during the CIRP. So people, there has been material irregularity. Sir, the powers exercised by our resolution professional, he has not done it properly, sir. Second one, the debts owed to an operational creditor of the corporate debtor have not been provided for in the resolution plan in the manner specified by the board. I told you, Noda, whichever is higher. Sir, we have not provided like that. Operational creditors are paid less. So people, you can go for an appeal. The insolvency resolution process costs have not been provided. Hey, I told you, Noda, in resolution plan, that has to be your priority. The resolution plan does not comply with any other criteria. Any other criteria, sir, the law says, people, then you can file an appeal on that. Try to remember it. They can ask you what are the grounds for appeal. Any other criteria. Sir, consequences of non-submission of a resolution plan. Now, sir, what happens if I do not submit a resolution plan? What happens if I do not submit a resolution plan? Go back to your chart. Now, people, see, the CIRP shall be completed within a period of 180 days. People, within 180 days from the date of admission of the application, plus one-time extension of 90 days. Sir, because of some reason, people, if you are not able to complete the process within 180 days, people, one-time extension of 90 days will be given to you. Sir, we did not understand this part. They could have been a little more clear. I have tried to give you a little clearly, people. See, However, a CIRP shall be completed within a period of 330 days, including extension plus time taken in legal procedure. Hey, what is this, da? Sir, let us do our old school maths. 180 plus 90 should be equal to 270. This is how it's coming to 330, da. Ye kya hai, da? The law is telling you will be given one time extension of 90 days. Then where is that 60 days coming from? Huh? What is this, da? Hey, concentrate. What do they mean? People, I'm giving you time, correct? Yes, sir, you're giving me time. How much? 180 days time to accept or reject. Correct, people? Yes, sir, I agree, sir. Now, people, imagine there is some hearing which happens. Imagine at any given point of time, adjudicating authority, say someone has filed an application. So people, if everything happens in one day, it's okay. What if there is a hearing, people? Imagine people in NCLT hearing happens, court authorities, they will call you and they will say, stop for a while. Because there is a case which needs to go. I cannot just give you like that. I need to hear to both the parties. Sir, in such cases, what will happen? So the law says people, 180 days plus 90 days, correct? Imagine if at all there is any legal proceedings, any time taken. Yes, so because of any such reason, people, because of that, if there is a delay, because of any legal proceedings happening in the court or because of any hearings that needs to happen, if there is a delay, people, then the law says, people, all the delay, everything put together should not exceed 330 days. So that extra 60 days is given, people, for counting such legal proceedings. Yes, sir, what do you mean by that? Imagine, people, file application with adjudicating authority. Adjudicating authority, people, within 14 days, it may accept or reject, correct? Now, sir, imagine, people, the adjudicating authority wants some more information. So what it will do? It will say, now imagine, people, I have filed today. I have filed my application today. I filed on 1st. The law says, people, you have 14 days time. Who? Adjudicating authority. People, adjudicating authority opened the file on 10th day. And they saw, people, they are not able to come at a conclusion. They want more documents. So what they will do, people, they will ask for the parties, say corporate debtor or financial creditor or operational creditor, for some more documents. Are you getting the point? Sir, now what if these people say, yes, sir, we will give you, and they take another 1 day or 2 days time? Why should it be calculated in 14 days? Is it pending with adjudicating authority? No, no. It is pending because of them. So people, such days will also be included and overall should not exceed 330 days. That is the meaning. Is it clear? Now take the other way. Financial creditor has, operational creditor has filed a case on a corporate debtor. Yes, corporate debtor has raised a dispute. Sir, this is the reason I have not given him the money. People, now the dispute should go on. Are you getting the point? Sir, because of which if there is a delay, so that 60 days is for all of these scenarios. Read once. The CIRP shall be completed within 180 days. One time extension will be given, that is 90 days. However, CIRP shall be completed within a period of 330 days, including any extension, that is 180 plus 90 plus time taken in legal proceedings. Is this clear? When the resolution plan is not filed within 180 days. Sir, you have given us 180 days time. Now, or such other extended period also. So I was not able to file even within the extended period, 90 days also. Now, NCLT people may, I'm not saying every time it will, it may directly pass an order for liquidation. People, I'll tell you one thing. Shall I tell you one thing? Yes, sir, please tell. This is the loophole in the act. This may is the loophole in the act. Why, sir? I'll prove you. Wait. People, this is Videocon's public announcement. Yes, people. Let us look at the corporate insolvency commencement date. People, look at the corporate insolvency commencement date. June 2018. 2019, 2020, 2021, people 2022 is also coming. Where is this 180 days, 330 days condition? Da? Where is this condition? So people, this is second loophole in the law. The timelines are not being met and the NCLT has put the word called may. If the resolution plan is not agreed according to initial things, people, what did we agree? Initially, what did we say? If at all you have not submitted the resolution plan within 180 days, then we'll straight away liquidate the company. If you say may, people, then it is optional. We will try the last day. We will pull the matter. If we are not able to, that time we'll see, people. So people, because of which we are not able to, what do you say? We are not able to give that timely thing here. It is not happening. Are you getting this point? See, 2018, people. Everything started on 2018. See everything. Look at the meetings only. Committee of Creditors, 6th, 7th. Intimation for extension of date for submitting the resolution plan for Videocon Industries and other 12 entities under Regulation 30, read with Clause 16 of SEBI LODR. Yes, people? The last date for the resolution of the submission plan has been extended to March 16, 2020. That is also crossed. See, extension of time. Intimation of the approval of a resolution plan by the Committee of Creditors and filing of resolution plan with Honorable NCLT. Videocon Industries. People, this is what I told you. So people, one particular plan was approved, people. So we are filing that, yes, this plan is approved with NCLT, resolution plan. Committee of Creditors has agreed. December 16, 2020. And again, see, there were appeals filed on that. Now people, 24th meeting of Committee of Creditors. 11th October 2020. It is still going on. If you guys want, can just come here and see, people. You can see how much is the operational claims. You can see everything. You can see everything. Yes, see here. Now that we know everything, now see the percentage, you will get a fair idea. Report certifying constitution of Committee of Creditors in the manner of State Bank of India versus Videocon Telecommunication. Now see, people, following members being financial creditors of Videocon Telecommunication shall constitute a COC. The preliminary voting share of each member is indicated below. People, SBI is always the topper because we will give the entire money, all our money, taxpayers. 23.98%. Central Bank of India, 16.27%. Total 100%. Is this clear? All of you getting a fair idea? The list of creditors is based on claims received and is subject to updated modification and variation. We have received over 150 claims for what is this? 150 claims for over emails. and hard copies. While every effort has been made to screen the claims received and collate the list of creditors. Okay, can you see this video con? Yes, people. So this is the, see, look at the percentage. All banks done. No bank is excluded. Correct, all of you. All banks only see. SBI, Central Bank, Corporation Bank, Canara. No other person will be there. Yes, got a fair idea, all of you. Okay. So now whatever you read, whatever you see, whatever you solved, everything is making sense. Okay. So sir, now 180 days is given. Correct? Okay, sir. Now people, IBBI, that is, we passed one order, people. The board passed one order. What is that order? On 18th March 2021, under Regulation 40A. What was this, people? This Regulation 40A, it provides a model timeline for carrying out various activities which is envisaged in CIRP. So people, under 40A, they have given a model timeline within what time which activity should happen. Regulation 40B of the CIRP regulations require that interim resolution professional or a resolution professional to file a set of forms. What set of forms? CIRP 1 to CIRP 6. When? Within 7 days of completion of specific activities to enable monitoring progress of CIRP. Now what is this, people? People, we have forms from CIRP 1 to CIRP 6. Every form indicates, people, after you do this, you need to intimate authority. For this, you need to file this form. The law says, people, after finishing that particular activity, within 7 days of finishing that activity, you need to intimate the authority that this activity is done. Sir, why, sir? It will help us monitor the process, which stage it is, what is happening, we'll get to know. Read. Require an IRP or RP to file a set of forms, CIRP 1 to 6, within 7 days of completion of specific activities to enable monitoring progress of CIRP process. People, this implies that form CIRP 1 to CIRP 6 would not be filed. So people, sir, if I have not, you said you have to file within 7 days of completion. What if I did not do that activity? Then you should not file until you complete. Until would not be filed until the related activity is not completed for whatever reason. If you complete only, then file. If you don't complete, you can't file. Is this clear, all of you? Okay, sir. Regulation 40B of CIRP regulations require one more form called Form CIRP 7. When should I file, sir? Within 3 days of due date of completion of any activity stated in column 2 of the table. I'll show you the column 2. Below is delayed, and continue to file form CIRP 7 every 30 days until the said activity remains incomplete. Now what do you mean by that, people? Listen carefully. Sir, company says for these activities 1 to 5, you need to file form CIRP 7. Sir, when should I file? The law says you have to file this within 3 days. 3 days of what? 3 days of the time limit given to you to do that particular activity. Now see. Read once. Within 3 days of the due date of completion of any activity stated. So people, if you do not do within the 3 days of the due date also, you need to file. We'll see what does it say. Activity requiring filing of form CIRP 7 if not completed by the specified date. People, if you have completed, you will file CIRP 1 to 6 noda. If you have not completed within due date, 3 days time will be given. You will have to file CIRP 7. If you have done, people, CIRP 1 to 6 will come into picture. So people are getting the point. It is like a default form. Okay, sir, public announcement should be made by T plus third. T, people, the day on which insolvency process has been commenced. Adjudicating authority has agreed. So you need to give a public announcement within that day plus 3 days. Correct, people? Why I told whenever I say within 3 days from the date of commencement of insolvency commencement date, from the first day will be always excluded. Yes? So people, 3 days time is given to you. Sir, in 3 days if I do not file, people, so T plus 3, you did not file plus 3. Sir, I should have imagined, people, on Jan 1st. Sir, insolvency commencement date, that is adjudicating authority accepted my application. The law says within 3 days you have to give a public announcement. Sir, imagine I did not give. If you have given, people, you will file CIRP 126 within 7 days of completing the task. Sir, imagine I have not given this. The law says, okay, I'll give you another 3 days time. File CIRP 7. Sir, how much long I need to file? First you file whenever you made a default. And I'll give you 30 days time. Even in 30 days you have not completed, again file. Another 30 days time. You have not completed, again file. So public announcement is not made by T plus 3rd day. Appointment of resolution professional is not made by T plus 30th day. So what you get? T plus 30 plus 3. Information memorandum is not issued within 51 days. Information memorandum is not issued within 51 days from the date of public announcement. From the date of public announcement. RFRP, request for resolution plan. RFRP, request for resolution plan. So you are inviting bids, resolution plans is not issued within 51 days from the date of issue of information memorandum. So preparing information memorandum within 51 days from public announcement. Once you issue information memorandum, 51 days, you have to request for resolution plans. The time for them to come up with a draft. Yes, sir. So if not, people, 3 days. File CIRP 7, 3 days. File CIRP 7. People, last, CIRP is not completed by T plus 180th day. The day of admission, that day exclude it off. Plus 180 days. Clear? I hope you are getting the point how to calculate also. Sir, plus 3 days. Yes, people. So date specified in column 2 plus 3 days, you need to file the CIRP 7 for the first time. After that, for subsequent filing, meaning, people, sir, even after 30th day, it is still pending. People, again you will file. Sir, 60th day, it is still pending. You will again file. Sir, 90th day, it is still pending. People, you will again file. Sir, X, people, from the day you had to file. Now read. Within 3 days from the due date of the completion of any activity stated in column 2 and continue to file form CIRP 7 every 30 days until the said activity remains incomplete. So 30, 60, 90, 120, 150, 180, you will keep filing until the activity you have not done. Which form? CIRP 7. So CIRP 126 for what you do. CIRP 7 for what you won't do. Is this clear? All of you. Got the table also. Yes, people. So people, by this, people, we complete your, I'm just dividing this as part A. Why, sir? Part A just has your IBC part. Yes, people. So let us assume that we have completed part A of IBC part. This is the maximum part. We are left with 3 chota parts, people. One is liquidation. Next one is PPIRP. Next one is voluntary liquidation. If we are done IBC, what? Sir, Raja, done, people. All of you. Okay. Okay, people. People, read and come, people. This was your resolution plan. You read. If you guys have any doubt, let me know. Yeah. Then I'll try to look into it and I'll try to get back to you. Is this clear? Thank you, people.